Every brand wants to be unique, identifiable, and unforgettable. But sometimes the logo or symbol that makes a brand so powerful can also make it vulnerable. In this episode of Trial by Podcast, Bridgette, Pippa, and I unpack trademark dilution in plain English. We'll explain what dilution is, how it differs from ordinary trademark infringement, and why it focuses on protecting famous brands even when no one is confused. We'll also ask a bigger question. If countries like the United States and Europe have embraced dilution laws, why haven't Australia and New Zealand? And do we need them? This is a conversation about brand power, legal boundaries, and where trademark law draws the line between protecting reputation and preserving competition.
So let's start with the basics. At its heart, trademarks are about one main thing: identifying where goods or services come from. A trademark connects a product back to a particular business, which is its source. A trademark tells consumers this product comes from this business. That's what we mean by its source identifying function.
Exactly, and that's why trademarks matter. They help consumers make choices and they help businesses build reputation and trust over time.
And not all trademarks clash with each other. The law recognises that the same or similar marks can coexist peacefully if they are used for different kinds of goods or services.
And so that's where the class system comes in. Trademarks are registered in specific categories called classes under the NICE classification system. So, for example, you might have the same or similar name used in completely different industries, say cosmetics and motor vehicles, and that can be okay.
So when someone applies to register a trademark, they must nominate the classes that reflect how the mark is actually going to be used or how it's genuinely intended to be used in trade.
Right, but generally, infringement happens when someone uses a mark that's identical or deceptively similar for the same or closely related goods or services, and it causes consumer confusion.
Yeah, that's correct. So now we can get into trademark dilution.
Okay, so here's where things get interesting. Consumer confusion doesn't explain everything. Sometimes, especially with really famous brands, the problem isn't confusion, it's actually something else.
Trademark dilution is about protecting the strength and the uniqueness of a famous trademark, even when no one is confused. So unlike normal infringement, dilution is not about confusion at all. It's about what happens when a brand's identity gets weakened.
Because this kind of harm can happen even when products are totally unrelated. Dilution works across different markets. It cuts through the usual class system in trademark law. The idea is that a trademark, it's not just a label that tells you who made something, it's actually a valuable commercial asset in its own right.
Yeah, and that value doesn't appear overnight. A famous brand becomes distinctive because of years of use, advertising, and consumer recognition. If other businesses start using the same or a very similar mark in unrelated areas, the mark can start to lose what makes it special. Over time, it stops feeling unique and becomes less powerful as a brand.
So, for example, imagine someone starts selling vacuum cleaners or gym equipment under the name Google. No one's going to think that Google's making those products, so there's no confusion per se.
From this point of view, dilution law is actually really about protecting the selling power of a trademark, not just its role in preventing confusion.
The idea has always been controversial. Critics argue that trademark law isn't meant to protect brand value for its own sake or guarantee companies a return on their advertising spend.
So if consumers aren't confused and they know products come from different sources, the real question is, why should the law step in at all? They warn that dilution protection can give famous brand owners something close to a property right over words themselves, shrinking the space for legitimate commercial activity and even creative or expensive uses by others.
Famous trademarks carry strong mental and cultural associations. From a psychological perspective, they work almost like a mental shortcut. When we hear names like Google, Nike, or Apple, our brains instantly activate a whole set of stored ideas about the quality, the innovation, trust for the brand, or status without us even having to think about it consciously.
Yeah, dilution law recognizes that these automatic associations actually have value in themselves. They're a result of repeated exposure, advertising, and experience, which over time hardwires the brand into a consumer's memory. So even when there is no confusion, a legal connection can still exist because the mark triggers recognition.
Yeah, and that's the key point. Dilution isn't about mistaken belief, it's about that mental association. Even when consumers know the brand owner isn't involved, that psychological association is still there. And it's the mental link created through memory, familiarity, and recognition that dilution law is concerned with protecting.
And this kind of protection is really reserved for famous marks. Dilution law isn't concerned with ordinary trademarks and small brands because most marks simply don't carry that same deep mental or cultural association.
So from both a mental and psychological point of view, the concern only really arises where a mark is so widely recognised that it automatically triggers recognition across the broader public. If a brand hasn't reached that level of fame, using a similar mark in an unrelated market is actually unlikely to activate those stored associations in consumers' minds, and therefore there'll be nothing meaningful to dilute.
Right, and a famous trademark isn't just a label. Over time, it picks up distinctiveness, reputation, and pulling power. That value comes from years of use, marketing, consumer recognition, and serious financial investment. Dilution law is aimed at stopping that value from slowly leaking away.
You'll often hear dilution described through two ideas: blurring and tarnishment. Blurring is what happens when a mark pops up in so many different places that it stops to feel unique, and it loses its sharp edge. Tarnishment is about reputation, using a famous mark in connection with low quality, controversial, or unsavory goods that can drag down what the mark stands for, even if no one is confused about the source.
From a policy perspective, dilution protection is about preserving the commercial magnetism of famous marks. These marks do more than tell consumers who made the product, they signal status, quality, and trust. They carry meaning.
So that's the core justification. If the law didn't intervene, repeated unrelated uses could gradually erode the power of a famous trademark simply because it has become successful. Dilution protection is designed to stop success from becoming its own undoing.
So let's look at how other jurisdictions deal with this. As we know, both the United States and Europe have trademark dilution laws.
So first, in the United States, trademark dilution has long been recognised as a distinct cause of action. Under the US Federal Trademark Dilution Act of 1995, owners of famous marks were given a tool to protect their brands even when there was no likelihood of consumer confusion.
One of the most famous early dilution cases is Mosley and Victoria's Secret Catalog Incorporated, and the facts alone make it very memorable. Victor Mosley ran a small lingerie and adult novelty store in Kentucky called Victor's Little Secret, which sounds very familiar to a well-known brand, Victoria's Secret, the globally famous lingerie brand. They sued Mosley under the Federal Trademark Dilution Act, arguing that his use of a similar name diluted the distinctiveness of their well-known mark. The key legal question before the US Supreme Court was what exactly a plaintiff has to prove to succeed in a dilution claim. Victoria's Secret argued that it should be enough to show a likelihood of dilution. In other words, that the defendant's use was likely to weaken the famous mark over time.
And the Supreme Court disagreed?
Exactly. The court held that under the law as it stood at the time, a plaintiff had to prove actual dilution, not merely a risk or likelihood of it. Evidence that consumers were confused or even that they found the association distasteful wasn't enough. There had to be concrete proof that the distinctiveness of the Victoria's Secret mark had actually been harmed, and Victoria's Secret couldn't meet their standards, so they lost.
Yeah, so the decision was significant because it did make dilution claims much harder to win in the United States. In response, Congress stepped in. In 2006, it passed the Trademark Dilution Revision Act, which lowered the threshold and made it clear that showing a likelihood of dilution was enough going forward.
So Mosley is important for two reasons. First, it clarified that dilution law is about protecting a mark's distinctiveness, not preventing consumer confusion. But second, it reflected the US court's concern about giving famous marks overly broad protection without clear evidence of harm.
In that sense, Mosley shows both sides of the debate, I guess. The desire to protect famous marks, but also concern about giving them overly broad rights. It illustrates a long-standing tension in trademark law. How far should the law go in protecting the commercial power of famous brands?
Yeah, and I think that tension helps to explain why some jurisdictions, most notably Australia and New Zealand, have remained cautious about adopting dilution doctrines at all. One common explanation focuses on cultural and economic context. In places like the United States and much of Europe, there is a long tradition of very large, highly visible brands operating across borders for decades, sometimes even centuries. Think about brands like Coca-Cola, Nike, Apple, and McDonald's. These marks are instantly recognizable across cultures and generations. They carry meanings that go far beyond the specific products that they sell.
Yeah. In Europe in particular, luxury and heritage brands like Chanel, Louis Vuitton, Hermes, Rolex, and Gucci, for example, function almost as cultural symbols. They signal status, taste, and lifestyle, and they're deeply embedded in popular culture, in Europe in particular. In these environments, a trademark is often seen not just as a business identifier, but as a form of cultural and economic capital. Because of that, lawmakers in the US and EU have been more receptive to the idea that some marks deserve protection beyond confusion. In the EU, this is reflected in Article 9, subsection 2C of the EU Trademark Regulation, which expressly protects marks with a reputation against dilution and free riding.
So there's also an economic policy angle to all of this. Both the US and the EU place significant weight on protecting investment in branding and advertising, particularly for companies operating on such a global scale. Dilution law is often justified as encouraging those investments by assuring businesses that the distinctiveness they build won't be gradually worn down by others trading on the same name.
Yeah, by contrast, countries like Australia and New Zealand have traditionally taken a more restrained approach to trademark rights. Their trademark systems have focused on competition, market access, and preventing consumer deception, rather than preserving that commercial magnetism. There have been some greater skepticism about giving owners of famous marks what can look like monopoly over ordinary words or symbols, especially where there is no confusion and where the markets are entirely unrelated.
So the difference isn't just legal. It reflects different ideas about what trademarks are for. In the US and EU, dilution fits within a broader acceptance that some brands become so powerful that they merit exceptional protection. In Australia and New Zealand, the prevailing view has been that success alone shouldn't expand trademark rights beyond their core function, and that dilution risks tipping the balance too far in favor of brand owners at the expense of competition and expressive freedom.
In Australia, a major reason trademark dilution hasn't been embraced as a standalone doctrine lies in the structure of the law itself, particularly the way distinctiveness is built in from the very beginning. On top of that, Australian law already provides powerful tools outside the trademark statute itself.
Under Section 18 of the Trademarks Act 1995, distinctiveness isn't something that gets assessed later at the enforcement stage. It's a threshold requirement for entry into the system. To be registered at all, a mark must be capable of distinguishing the applicant's goods or services from those of others.
So, to put simply, if a sign doesn't function as a meaningful indicator of trade source, you don't even get through the door. That means marks that are too descriptive, too generic, or too commonly used are filtered out early. What remains are marks that already possess real distinguishing power. From an Australian perspective, that process is doing much of the work that dilution law is said to do elsewhere without departing from those confusion-based principles.
And there's also a deeper skepticism at play, particularly when it comes to protecting the monopolies of very large brands. Section 18 reinforces a core Australian idea about trademark rights. They're earned through use that distinguishes, not through fame alone. The law is less interested in whether a mark has cultural magnetism and more concerned about whether it tells consumers who they're dealing with.
So from this point of view, if a mark's distinctiveness is so fragile that it can't survive unrelated uses in markets where no one is confused, the Australian position is that this isn't a problem trademark law really needs to solve.
Additionally, Australia does have other safeguards. Australian law already offers additional protection for well-known marks beyond strict class boundaries. In Section 120, subsection 3 of the Trademarks Act 1995, this section allows infringement of a well-known trademark to be established even where the goods or services are unrelated. If the alleged infringer uses a substantially identical or deceptively similar mark that suggests a connection with the owner of the well-known mark and is likely to harm the owner's interests. This provision in the Trademarks Act differs from the trademark dilution laws because it does require an indicated connection to the original well-known mark.
Additionally, under Australian consumer law, Section 18, a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. We also have a common law tort of passing off that prevents one trader from misrepresenting their goods or services as being those of another, thereby damaging the other business's reputation. Passing off protects business reputation from deceptive imitation, even without a registered trademark.
And these doctrines allow courts to intervene where conduct creates false associations, exploits reputation, or misleads consumers without abandoning the core focus on truth in the marketplace.
So rather than importing a separate dilution doctrine, Australia relies on distinctiveness as the gatekeeper and confusion or misleading connection as the limiter. The result is a trademark system that prioritises competition and clarity in the marketplace and remains cautious about extending protection simply because a brand has become famous.
So, should Australia have trademark dilution? One argument for introducing trademark dilution in Australia is the nature of branding has changed over the recent years. Modern brands, particularly those operating digitally, often expand rapidly across industries, platforms, and cultural spaces. A mark may begin life in one class but grow to signify a broader commercial identity that is no longer neatly contained by traditional goods and service categories. In this environment, the class system can lag how consumers experience brands.
A clear example often used to illustrate this argument is Amazon. Amazon started off as an online bookstore operating squarely within a single narrow goods category. Today, however, the Amazon mark signifies a much broader commercial identity: cloud computing through AWS, video streaming, smart home technology, logistics services, groceries, publishing, and even healthcare.
Yeah, so from this perspective, dilution protection could actually be seen as recognising a brand's growing maturity. As some Australian marks grow to national or global prominence, their value increasingly lies not just in source identification within a class, but in their symbolic and reputational strength across markets.
A clear example of this in Australia is Canva. Canva began as a simple online graphic design tool, initially associated with a narrow set of digital design services. Today, however, the Canva brand signifies something much broader: a global design platform, workplace collaboration tool, content creation ecosystem, and even an education and publishing infrastructure used by individuals, businesses, schools, and governments worldwide.
Dilution law would offer protection for these types of marks during the vulnerable phase where they are expanding beyond their original categories, but before they have secured registration across every conceivable class.
So, on the other side of the coin, the commercial incentive argument for dilution is often viewed more cautiously in the Australian context. While it is sometimes suggested that introducing dilution protection could signal that Australia is a jurisdiction that strongly protects high-value intangible assets, thereby encouraging greater investment in branding, marketing, and global expansion, this framing sits uneasily within Australia's broader regulatory culture. Australian governments have traditionally been reluctant to appear as though trademark law exists primarily to serve large commercial interests or multinational brand owners.
This helps explain why Australian policy discussions tend to resist dilution rhetoric grounded in investment incentives alone, and instead continue to emphasize balance, competitive neutrality, and restraint in the expansion of trademark rights.
Finally, advocates for dilution law argue that it could operate as an exceptional and tightly confined doctrine, applying only to a very small class of truly famous marks. On this view, dilution wouldn't undermine the traditional class system. Instead, it would sit at the very top end of protection, where marks no longer function primarily as indicators of trade source, but as market-shaping tools and assets whose value lies in reputation and symbolism rather than product category.
So despite these arguments, there has been no strong policy push to introduce dilution into Australian law. The central reason is that the existing system is widely seen as already doing the necessary work.
Australia's class-based registration system provides brand owners with a clear and incremental pathway as their business grows. When a mark expands into new areas, the owner can extend protection by registering in additional classes. Protection is therefore tied to actual or intended commercial activity rather than abstract notions of brand value or status. From a policy standpoint, this approach is viewed as more predictable, transparent, and fair than granting expanded rights simply because a mark has become famous.
Right, and you also do have to consider our passing off well-known marks and ACL provisions.
Seen this way, the debate over dilution in Australia isn't about ignoring how brands evolve or denying that reputational value can exist beyond classes. Rather, it reflects a view that the law already has sufficient tools to protect strong marks without introducing a doctrine that risks decoupling protection from use, competition, and consumer understanding.
From an Australian policy perspective, dilution can start to look less like consumer protection and more like rewarding commercial success with expanded monopoly rights. And without a clear gap in the existing framework, the incentive to introduce dilution as a standalone doctrine has remained weak.
So do we really need to choose a side? The question is not whether one model is right and the other wrong, but whether explicit dilution protection would add sufficient clarity or benefit to justify its costs. Importantly, Australia's decision not to adopt dilution does not deny that brand value exists or matters. It simply reflects a judgment that this value should remain mediated through use, reputation, and market context, rather than protected as a standalone legal interest.